so that we can share this out with you all after. And we'll go ahead and dive right in. We have a lot to cover today. And I'm going to do really uh, focused attention on this topic to try and cram all of this in. But I'm very thankful that you all could join us for this overview of Treasury's interim final rule for the ARPA Flexibility Act. I'll just dive right in here. So what is the Flexibility Act and why do we have a new interim final rule? As if Treasury couldn't put enough on our plates. They actually were required to issue a new interim final rule because last year, Congress in the Consolidated Appropriations Act of 2023 included an amendment that broadened the eligible uses of your ARPA SLF RF, or what some of you lovingly refer to as SLRF funds. This broadened scope of eligible uses includes surface transportation projects, projects that would be eligible under Title I of the HUD Act, so CDBG projects, and emergency relief from natural disasters. Now, the caveat to these eligible uses being eligible for use is that Treasury had to issue rules for them. And those rules were technically due February 27th of this year, but Treasury released these on August 10th. So kind of, I think, ahead of schedule, I think, of what a lot of people expected. But we have them now, and we have a period to start reviewing them. Because it is an interim final rule and it was released without comment, it is technically in effect as of August 10th, 2023, but there is a comment period that will start 60 days from when the interim final rule is published on the Federal Register. And I didn't check the register this morning. I don't know if it got published today, but as of yesterday, it was not on the Federal Register yet. So the 60-day window to comment has not opened. But as you become familiar with the interim final rule, if you have comments and you would like Treasury to clarify things, that open comment period will be the time to make your request before the final rule is issued in about 90 days. So it's important to remember that these are new eligible use categories, and this interim final rule does not change or supersede the previous final rule. So all of the rules that you have been working under are still in effect. This just supplements those. And these eligible use categories are effective as of December 29th, 2022. So any costs that you've incurred since December 29th of last year in any of these categories would be eligible. So let's dive into the different categories. We're going to start with surface transportation and Title I projects. And these two are lumped together because there are some general rules that apply to both of these eligible use categories. First, the interim final rule allows you or caps the amount of your SLF RF funds you can use for these types of projects combined. So that cap is $10 million or 30% of your award, whichever is greater. And that, remember, is combined. So if you decide to do surface transportation and Title I projects, they have to be less than 10 million or 30% of your SLFRF funds. In addition, there are certain rules that will apply kind of across the board to these eligible use categories. So for all of the surface transportation projects, you're looking at compliance with Titles 23, 40, and 49 of the U.S. Code. The NEPA, the National Environmental Policy Act provisions will apply to either surface transportation or Title I projects, depending on if infrastructure is being built that requires those types of environmental reviews. Of course, the HCDA applies to all of your Title I projects. Talk a little bit more about that in a minute. And then kind of general requirements like prevailing wage and those types of things will also apply across the board. It's very important to keep in mind, and Treasury has stressed this at several points in the interim final rule, these funds are meant to supplement, not supplant, any other funding that you have. So while you can pursue new projects, if you're going to use these funds to broaden the scope or cover unexpected expenses for your current surface transportation or Title I projects, you have to be cautious to make sure that you're not supplanting other federal, state, or local funds that you're already receiving. Another across-the-board requirement, operating expenses are not allowed. Treasury is viewing these two eligible use categories, surface transportation and Title I, in much the same way they are viewing the other infrastructure projects like sewer and water and broadband. So operating expenses are going to be the extent, or are going to be excluded from what you can use your SLFRF funds for in these projects. It's also important to keep in mind that Treasury has provided a provision within the interim final rule that if you use your SLFRF funds for projects in surface transportation or Title I, they do not increase your cost share requirements. So if you're already doing surface transportation projects and you want to use some of your funds to expand one of those projects, those funds, that use of funds is not going to increase your federal contribution to the project and therefore would not increase your cost share component. However, there are certain caveats to that, right? There are certain programs, particularly in transportation, that have a cap on the limit, the cap on the federal funds that you can use for those projects. And so if you contribute SLFRF funds to one of those projects, you do not increase your cost share component up to whatever the federal cap is. Now, if your SLFRF funds go over whatever the federal cap is for that type of project, then anything in excess of the federal regulated or statutory cap would be subject to additional costs there. So something to keep in mind as you're kind of designing and determining how you're going to use these funds. The other really big thing, the reason that it's bolded, is for surface transportation and Title I projects, you still have to obligate your funds by December 31 of 2024, but you have to expend them. You have to spend the dollars by September 30th of 2026. So you have 3 less months or 3 fewer months to spend those funds, even though the obligation dates are the same. It's an important caveat to keep in mind as you're planning out your projects and how you're going to execute them. Treasury really wants you to be able to get projects finished with the ARPA funds, which are intended to be one-time use. Okay, so that's the general overview. We're gonna dive into specifically surface transportation projects. And Treasury has established 3 different pathways that you can pursue surface transportation projects. The first one is if you are already receiving Department of Transportation funding. This is federal Department of Transportation funding, either directly or through pass-through from your state. If you are already receiving DOT funding, or you are anticipating or expect to receive DOT funding for a project that will be obligated by December 31st of 2024. And in other words, DOT will issue the funds to you, or your state will issue the funds to you by December 31st of 2024, then that's considered a DOT funded project for the purposes of this interim final rule, and will allow you to use your ARPA funds to cover all or some of the expenses of those projects. So what does that look like? First of all, because these are projects that the Department of Transportation is already funding, Treasury is requiring you to get pre-approval from the Department of Transportation to use your SLFRF funds to supplement those projects. And this is particularly important for certain projects like infra and raise, which have very tight eligibility guidelines and funding mechanisms. So you'll want to make sure that if you're going to pursue those types of projects, you've talked to your Department of Transportation or your state DOT awarding agent, and you have their written approval to use your SLFRF funds to supplement the project. The SLFRF funds, again, cannot supplant the funds that you're getting from the Department of Transportation or from the state, but you can use them to supplement the project. So if the project expands in scope, or if costs have ballooned, like we know costs are ballooning, and all of a sudden you don't have enough DOT funding to cover your project, your SLFRF funds can be used for that. Now, an important caveat of this pathway only, Treasury has authorized the Department of Transportation, the Federal Department of Transportation, to maintain oversight and administration of Pathway 1 surface transportation funded projects only. So if you have a DOT funded project and you're going to contribute SLFRF funds to it, Treasury will not be administering that or overseeing that project. The Department of Transportation will, and it'll be whichever mechanism your DOT funding is coming through is the mechanism that will be used to provide your oversight and administration. So what that means from an ARPA perspective is that you'll have less ARPA reporting that you'll have to do for your project and expenditure reports for those types of projects, but all of that reporting will be done through your Department of Transportation grant. So pathway 2, if you have a project that is not or will not get Department of Transportation funding, then Treasury has defined what they're called their streamline framework. And the streamline framework is a way to identify eligible projects that have a lower level of risk, either financial, compliance, or environmental wise, or a combination of those. Basically, what Treasury is saying is that if you have a project that's relatively low risk, doesn't require a Department of Transportation specialist, that level of specialties to oversee, and Treasury can oversee and administer the project, then it would qualify for this pathway 2. And what that means for pathway 2 is that you generally can move forward with these projects as long as they meet the eligibility requirements that are used for RAISE projects. So if you are familiar, if you've done any RAISE projects, you know what those eligibility criteria are. If you haven't, feel free to give me a call. Be happy to work with you to understand those eligibility requirements and decide whether your project fits within that scope. But if you are familiar with RAISE projects, then there's a couple of caveats to keep in mind. If you're using the streamline framework, you do not have to get Department of Transportation approval unless such approval would otherwise be required through some requirement of Titles 23, 40, or 49 of the U.S. Code. So basically, if you're familiar with doing transportation projects or infrastructure projects, you know that Titles 23, 40, and 49, which cover highways and transportation, they have some provisions that require Department of Transportation to pre-approve maybe certain aspects of your project, right? So if your project is, falls into one of those categories that DOT would have to do some additional approval for, you still have to proceed with that. But if it's just a general project that would be approved under RAISE, you don't need to have DOT approval. You can just move forward with that. The important thing to keep in mind here is Treasury is putting the responsibility on you as the recipient to document your determination of eligibility. In other words, you have to interpret what RAISE allows as an eligible project, and then be able to explain to and define and document for Treasury how your project meets those eligibility requirements. So again, if you're not familiar with it, it is a heavy lift. It does require some specialties in that area that if your city or county has not done surface transportation projects before using DOT funding, you may not be familiar with. Feel free to reach out to us. We're happy to help you answer those questions.
Rob, we do have a question in the Q&A. So Carrie asked, would we contribute existing SLFRF funds from the initial award?
Would we contribute existing SLF funds from an initial award? So if you're talking about from your initial SLF, SLF, let's say ARPA. Let's just call them ARPA funds because that's easier than the acronym. If you're using your ARPA funds, this would be like any other eligible use category, right? So if you have ARPA funds that have not been obligated for another project, or if you have ARPA funds that you deobligate and decide to use them for one of these projects, you're still pulling from that bucket of funding, right? So this is not revenue loss. This is not a new award that you're going to get. These are just another mechanism, another use category for your existing ARPA awards. Okay, hopefully that answered that question. Real quick, a couple more things on the streamlined framework. If you use the streamlined framework, you are not required to have an EPA impact review. That is because the assumption that Treasury is making is that this is a low environmental risk project, and it meets those regulatory and statutory definitions so that a review would not be necessary. Again, it's up to you to make sure that you've done your due diligence and can accept the risk that is associated with that. So if you have a project that's not Department of Transportation funded and it's not eligible under RAISE, but you still want to move forward with it using ARPA funds, Treasury has provided another little caveat. You can submit a notice of intent, and the interim final rule details what needs to be in that notice of intent, but you can submit a notice of intent to Treasury at this email address you see here, noe-slfrf@treasury.gov. A Treasury will review your notice of intent and will provide you with guidance on whether you can move forward with that project or not. We all know the delays that Treasury has in responding to anything. So if you are in the population that does not have a DOT funded project, wants to do a project that won't meet the requirements of RAISE, and you want to hope that Treasury will give you permission to move forward with it, I would suggest you get on that straight away. The window for doing infrastructure projects is closing really quickly. Just the lead time for design and procurement and contracting is so small right now. If you're going to pursue that, definitely do not hesitate in getting that process started. All right, I promised you one more pathway, and this is it. Treasury will allow you to cover the non-federal share requirements for certain surface transportation projects with your SLFRF funds, your ARPA funds. Those include infra grants, fixed guideway capital investment grants, mega grants, and any project that would be eligible for credit assistance under TIFA. And as an added bonus, if you have a TIFA loan, you can use your SLFRF funds to make repayments. So that is what I have for you today on the surface transportation grants. I'm going to pause for a second if there's any more questions before we move into Title One? I'm not seeing any.
No questions in the Q&A.
Okay. I think everyone's really excited for the Title I projects. I know I am. This is going to be an exciting opportunity for a lot of people who either have not had the opportunity of doing a CDBG funded project before, or who are looking to enhance their current CDBG program. But I wanted to really quickly touch on, for those of you who have not done a CDBG project, your jurisdiction maybe does not receive CDBG funding. This is an opportunity for you to do a CDBG style project with a much lower barrier to entry. And we'll talk about that in a minute when we talk about the exceptions to Title I that apply under the interim final rule. But for those of you who aren't familiar with CDBG or who may need a refresher, I want to focus for just a minute on the primary objective of CDBG, right? So in 1974, legislation was passed that basically consolidated a bunch of disparate federal programs geared towards housing and urban development and community enrichment into one community block grant style program. And the reason for this is because it gave jurisdictions across the country who are all dealing with very different circumstances and problems, the solution to be able to get a chunk of money from the government and within certain guidelines, use that within their community in the way that best fits them. So with that in mind, it's important to understand the primary objective of CDBG, which is the development of viable urban communities that provide decent housing and suitable living environments that expand economic opportunities and are principally geared toward persons of low and moderate income. So that's the primary objective. That's the mission statement of CDBG. You'll also hear people who work in CDBG talk about the national objectives, and that's the 3 bullet points that follow, right? The national objectives of CDBG is to benefit low and moderate income persons, to prevent or eliminate slums and blight, and to provide a source of funding for emergency or urgent existing conditions that pose a threat to health or welfare or the community, and in situations where other financing for those to address those issues doesn't exist. So that's the national objective and the primary objectives for CDBG. So if you're going to pursue a Title I project, it's important to keep those guidelines in mind, because some of the exceptions that Treasury has made to Title I eliminate some of the prerequisite work that is really ingrained with these primary objectives. And bypassing some of that work may not give you a full and complete understanding of what CDBG is meant for and how it should be used. I'll get to those exceptions in a minute, but first I want to talk about how you can use the funds. So this is a general list of CDBG allowable activities. I'm not going to go through all of these, but I did want to draw your attention to 2 because there are unique rules around them. Those are the public services and the planning activities. So, and the reason that those are unique is because the interim final rule puts a cap on the amount of funding that you allocate to Title I projects that can be used for those activities, right? So when we talk about a cap on this slide, we're saying that this 15 and 20% cap apply to the total amount that you obligate to Title I projects, not your complete ARPA, but just what you've obligated to Title I projects. So you can deliver public services up to 15% of what you've allocated to Title I projects, and you can engage in planning activities up to 20% of what you've allocated to Title I projects. And this is really in line with the intent of CDBG. If you have regular CDBG funds, you know that the 70% guideline, at least 70% of your CDBG activity has to be dedicated and geared towards providing benefits to low and moderate income households. So these caps kind of enforce the use of that 70% rule. A couple of important caveats to the eligible uses. You can do many of these activities as loan programs or revolving loan programs. If you decide to use your Title I funds in that way, you do have to follow Treasury's guidance on administering loan programs that is found in the final rule and subsequent guidance. So it's important, if you decide to go the loan route, that you're cognizant of what those rules are and how they may apply to your program. In addition, Title I includes not only these eligible use categories, but a number of others that are excluded from the interim final rule, right? So if you've had a CDBG DR or a CDBG mitigation grant in the past, those activities are not allowed using your interim final rule, under the interim final rule, right? So this is really geared towards addressing the issues of housing security, economic development, and those types of activities within eligible areas of your community. There are certain activities that Treasury has said are ineligible, and these are based off of guidance from Housing and Urban Development. You are not allowed to use your Title I funds for any type of general government expenses. That includes maintaining, purchasing, upgrading, or making improvements to any government building. So if you wanted to use CDBG funds to do your town hall, that's not going to work under the interim final rule. You also cannot engage in any political activities. You cannot purchase any equipment. You cannot cover operating or maintenance expenses. No new housing construction under Title I, and no income payments to individuals under Title I. Now, keep in mind, these ineligible activities only apply to the Title I use of funds. Many of these, with the exception of probably political activities, are eligible under other use categories in SLFRF, but they would not be eligible if you're allocating funds to a Title I project.
You've got one question in the chat there, Rob, about will HUD require an amendment to an annual plan if you use the funds for a Title I project?
That question is actually a great segue to my next slide, which is the exceptions to Title I. So the interim final rule does eliminate certain requirements in Title I that you would have been subject to if you had gotten a CDBG grant through HUD or through your state. Amongst those is portions of Section 104, which is the prerequisites that you would have to go through if you were to get a CDBG grant. Those include developing consolidated and annual plans, publishing those plans, engaging in community participation in your planning process. Those include, doing performance and evaluations that are submitted to HUD. Program income provisions are included in that, and the community development plans as well. So what that means is if you already have CDBG funds, you have a CDBG plan in place, you're going through the process with HUD to manage those grants, these SLFRF funds, your ARPA funds, can fund Title I type projects like we discussed, but it's separate from your normal CDBG grants, right? Because remember, we're supplementing, we're not supplanting. So you're not increasing your CDBG program with these funds. You're simply have a one-time use of additional funding to support those initiatives. So what that means currently is that, and we expect to get some clarification on this in the final rule, that means that you would not have to amend your current plans with HUD as it relates to your CDBG programs. Treasury is not giving HUD any authority or oversight of the use of Title I funds within the scope of SLFRF. So again, it's important that as you use funds for this use category, that you keep them separate from your other CDBG grant funds and account for them separately so that you can demonstrate to both HUD and to Treasury that you're using your SLFRF funds specifically for these projects and not commingling those with your other CDBG grant funds, which could then lead to questions of supplanting, and nobody wants that. We don't want that. So those are the general requirements. Treasury has decided to exempt these specific parts of Title I because Treasury feels that they largely are duplicative of other work that is already, or other requirements that are already in the final rule that you have to adhere to. And in the situation of the prerequisites, Treasury made the determination that if you had to go through the prerequisite requirements, the time it takes to do that and get through that process before you could obligate funds to a project would be too long and too cumbersome, and you would not be able to, at this point, see any benefit from that, and probably would not be able to use those funds for Title I projects because the lead time for planning is so long. So Treasury kind of gave you a break on that. So it's nice if you have a CDBG program, you can supplement that with your ARPA funds. If you have not had the privilege of having CDBG grants before, you can get a taste for what those projects are like without the front end kind of administrative work that gets to the granting phase. All right, that's what I have on Title I. Pause for a minute, catch my breath. If we have any questions on surface transportation or Title I projects. Okay. All right, let's talk about the natural disasters eligible use category. Natural disasters eligible use comes from allows for three different buckets of activities. There is emergency relief from a natural disaster. There is emergency relief from the negative economic effects of a natural disaster. And there's mitigation activities that will lessen or avert a natural disaster and its potential physical or negative impacts. I see that somebody has raised their hand. Medieval. If you're able to put your question in the Q&A or the chat, we'll be happy to get to it. And until that pops up, I'll keep going with the natural disaster component. So if you recall way back, 34 minutes ago, we were talking about the timelines for these funds. Remember that the new eligible use categories are for costs that were incurred on or after December 29th of 2022. That's important to keep in mind for the natural disasters because we're talking just about costs incurred. We're not talking about the date of the disaster. So if you had a disaster before December 29th of last year, but you incurred costs for that disaster after December 29th of last year, those costs that you've incurred after December 29th would be eligible under this use category. So important thing to keep in mind, I know we work with several clients that experienced fires and tornadoes last year that happened, earlier in the year that are really, still recovering from and addressing some of the issues related to those events. And this eligible use category will be a big benefit for them. So let's talk a little bit about what you can spend those funds on. This is the list that Treasury has enumerated as eligible use categories, but this is not a full and complete list of what you can use for funding. So keep in mind, this list is really meant as an illustrative example of what you can use funds for. There's a lot of things that aren't covered on this list, and I'll talk about a couple of them to give you some examples. But just to give you an idea, if you're responding to a natural disaster, you can cover costs like temporary housing, debris removal, increased operational costs. If your city or your county had to stand up your emergency operations center in response to a disaster, I know several of you in Florida are probably doing that today. Those costs are eligible under this eligible use category. You can also cover financial assistance to your residents and small businesses. That includes not only lost wages. You can do a lost wages program. You can also do a housing recovery program for residents who were uninsured or underinsured and had property losses to their primary residence. You can also cover any type of emergency protective measures you put in place. So for instance, if you were facing a severe snowstorm this winter and you went out and you salted the roads, that's an emergency protective measure. If you set up sandbags to prevent flooding, that's an emergency protective measure. All of those costs can be covered under your SLFRF as well. And then other immediate needs is kind of the catch-all. If you can identify a cost that's directly or, I'm going to say directly. There is a caveat to do indirect costs. It gets a little bit more cumbersome. And if you want to go down that road, I'd be happy to talk to you about it. But the easiest solution is any of the direct costs that you have related to responding to a natural disaster would be covered under your SLFRF. Keep in mind, though, again, we're supplementing, we're not supplanting. So if you have FEMA assistance, if your state appropriated funds for disaster response, these SLFRF funds have to supplement those other funds, right? So you want to use up those funds before counting on your SLFRF funds, or you want to identify costs that won't be covered under other funding sources that would be covered under SLFRF. The other really exciting from my standpoint kind of approach to using this eligible use category is preparing your city or county for the threat of future natural disasters. And the list that Treasury provides here is drawn from FEMA's Hazard Mitigation Assistance Guidance. But it just kind of touches on the basis of things that your city or county can be doing to prepare for future natural disasters. And any project that you want to consider that goes down the line of preventing or averting losses related to future natural disasters are potentially eligible under this category. I get really excited about this because what we do at DRS is so heavily focused on disaster response and recovery. And this is just one small component of a lot of funding that's available from the federal government right now to create more resilient communities that are more responsive and prepared for natural disasters. If you are considering allocating some of your ARPA funds to mitigating future natural disasters, I would love to speak with you. I'd love to tell you about the other programs that you could also take advantage of to make your communities more resilient. And I would really encourage you to reach out to me. My contact information will be at the end of the presentation, but would love to talk to you about what we can do to improve the resiliency of your communities. Okay, away from my marketing spiel and back to what you were here to hear. These are the general eligible use categories. Some of the other things that would be responsive to a natural disaster, allocation of emergency responders and overtime would be eligible. Any materials that you may have had to purchase to be responsive, temporary structures for those types of activities, any costs you may have incurred for evacuation measures. Again, drawing the connection between the designated natural disaster and your costs are important. And I would be remiss if I didn't define what a natural disaster was in this situation. The interim final rule actually provides a broad latitude in defining what a natural disaster is. Obviously, a declared disaster, either at the federal, state, or local level, would be considered a designated natural disaster. But Treasury also allows your executive of your jurisdiction, whether that's your mayor or your county manager or board of commissioners or what have you, to define a natural disaster. And that kind of gets into this two-part proof of eligibility that Treasury requires. In order for costs to be eligible under this category, you have to identify a natural disaster. Again, this is an illustrative list of what a natural disaster could be. Generally, it varies from region to region. The natural disasters that your community, is at risk for. So this should help you to kind of narrow down what is the natural disaster that you're addressing, whether it's one that has already occurred or one that you're preparing for in the future. Once you've identified that natural disaster, you need to identify the emergency relief that's responsive to it. And what Treasury has defined as emergency relief is assistance that's needed to save lives or protect property, public health and safety, or to lessen or avert the threat of a catastrophe. They're really providing a broad definition of emergency relief to allow you to maximize the use of your ARPA funds for your disaster response. The caveat with that, as with all of the eligible use categories, is your costs have to be related to and reasonable in proportion to the physical risk or negative economic impacts of the disaster, right? So you want to make sure that if you are defining a disaster, you understand the impact that it had on your community or potentially could have had on your community. And the costs that you're claiming for response are reasonable and proportional to that disaster. Now, one of the questions I know has come up with some other people that I've talked to, other cities that I've talked to ahead of this webinar is, we were told that a disaster was going to happen. The state or the county declared an emergency. So we took measures to prepare, but then, for whatever reason, the storm missed us and, we ended up not getting hit. Are those costs still eligible? The answer is yes. If you can identify a specific disaster event that you were responding to and can justify the costs as reasonable and proportional to responding to that event, those are eligible costs, even if the event didn't actually hit your community as it was originally planned, or projected to. As long as you can demonstrate that there was a reasonable expectation that you are going to be impacted by an event, then those costs associated with responding to that would be eligible.
And Rob, Carey asked, so it's to create more resilient communities, but it doesn't have to be directly in response to negative economic or health impacts of COVID-19, correct?
Yes, that is exactly true. So she brings up a good point. The natural disaster eligible use category is a use category that is not tied specifically to COVID-19. The statute and Treasury's interpretation of the statute allows that any natural disaster that you have experienced or you anticipate experiencing could be eligible. Again, you need to be able to identify and justify the impacts of that disaster. It doesn't have to be related to COVID-19. So tornado, like I said, tornadoes, earthquakes, fires, snowstorms, flooding, all of those things were eligible disasters that Treasury has enumerated. Treasury is taking the assumption that if you have received SLFRF funding, then your community is already one that was impacted by COVID-19, and the additional impacts of a natural disaster, either that did happen or potentially could happen, would exacerbate the effects of COVID-19 in your community. And therefore, by providing responses to natural disasters, it enables you to lessen some of those impacts that are directly or possibly indirectly tied to COVID-19. Good question. Okay, so what are our key takeaways for today? The first one is these new eligible use categories are going to allow for greater flexibility of your SLFRF funds. We talk to a lot of cities and counties that are struggling with how to use their funds, and where to allocate them, and the window for obligating those funds is closing pretty quickly. These eligible use categories provide some new mechanisms and avenues to pursue in using your funds. Another key takeaway is that there are significant compliance requirements with these eligible use categories. Treasury has not provided a whole lot of direct guidance in how to do your eligibility assessments and determine those requirements. So there's a lot of due diligence that's involved with this. A good example of that is the surface transportation projects. A question that I'm surprised I didn't get was, what is a surface transportation project, right? The interim final rule defines surface transportation projects as those that are eligible under a list of eligible uses found in Title 23 of the US Code. That's a pretty exhaustive list. And so when you're thinking about whether my project meets the surface transportation eligible use category, keep in mind, we're not just talking about highways here. We're talking about bridges. We're talking about main thoroughfares that contribute to tourism and travel in your community. We're talking about electronic vehicle charging facilities. There's a broad spectrum of what surface transportation can cover, but you have to understand what's involved in being compliant for those programs, and that requires, if you've not done that before, that requires some subject matter expertise. And that leads me into my third key takeaway. DRS is here to help you. If you've been on one of my webinars before, I love this stuff. I love sharing information. I love it when you guys reach out to me with questions. But more importantly, I love being able to work with you and really see the impact of change within your communities. So if you are one of those folks who is struggling with these new eligible use categories, or dealing with issues within the final rule, and you need somebody who does this day in and day out for the last 3-4 years, please reach out to me. We would love to have an opportunity to talk to you, share some of our expertise, and work with you in really creating resilient and vibrant communities where you are. So
we've got one question here from Kay Ryder with FAA Airports. Any information on resources on the revenue loss category and agency waivers?
Ooh, good question. I have not dealt too much with agency waivers. Typically speaking, Treasury has been pretty much non-committal in being responsive to anything that's not already documented in the final rule. So waivers from Treasury are going to be impossible. In terms of working with other federal agencies or possibly state or local agencies in terms of waivers, it's something that I haven't directly experienced with any of the clients that I've been working with. We have some strategies for going down that road if that's something that you need to pursue for your specific project. But yeah, I would say, I guess to answer your question, no, I don't have any specific guidance around agency waivers that is kind of general, broad strokes based. Having worked on other federal programs prior to ARPA and having gone down the avenue of agency waivers for other projects, it's kind of circumstance based, right? Some agencies are going to be more open to waivers than others will. So I know I said I don't have any general broad strokes, but I guess my general broad stroke would be, do your due diligence before you, submit for a waiver. Make sure that you understand the mindset and philosophy of the agency and why they enacted the rules or requirements that you're looking to get a waiver for, and be responsive to those things, right? You want to make sure that you're addressing concerns. The rules and regulations that the federal government puts out are largely guide rails. It's not, they're not carved in stone. The government is basically just saying, hey, we want to give you the flexibility to use these funds, but you have to stay within these parameters. If you're going to go outside those parameters, you need to be able to justify why, and why going outside those parameters is in service to the project that you're trying to accomplish. Great. Other questions? Got a few minutes left.
I just want to address, we had a question right at the very beginning. Will we be sending out these slides? Yes, we will send a follow-up email that has a link to the recording with the slides. So you'll be able to go back and reference these if you need to.
And for those of you who, so I did a ARPA webinar about a month ago or so, 6 weeks ago, prior to the interim final rule coming out. And those of you who are on that one already know this, but following up on this, we'll provide you with an opportunity to schedule a 15-minute call with myself or another one of our subject matter experts here at DRS. This is an opportunity for you to get a little bit more hands-on assistance with any questions that you might have. Again, we're able to answer questions on those calls in kind of general broad strokes. We won't have the benefit of being able to dive into your specific documentation and those types of things. But we're happy to address in those 15 minutes, basic questions or general insights that we can provide. But you can expect to find that link with the slides as well.
I'm not seeing any other questions.
Okay. They said that I couldn't wrap up a webinar early, and it looks like I've done it. I've saved a whole 4 minutes. So I really appreciate everybody for coming out. Again, follow up with me. That is my email address. That is my cell phone number. I prefer text, but if you're one of those people who like to call, feel free to give me a call. Always happy to talk about this. Oh, good question. Any procurement pointers or takeaways that we should look out for? Yes. Generally, procurement as a whole is something that you should look out for. But unfortunately, I don't have your name, anonymous attendee. But if you email me, I will send you a link to some of our material on ARPA compliance and federal procurement compliance. There is a lot that's there, more than I can cover in 3 minutes, more than I could cover in an hour. But I would be happy to share some of that information with you. Awesome. All right, everybody, you get 2 minutes back. Thank you all for coming. Look forward to talking to you soon. And good luck with your ARPA.